Welcome to the court gallery. This is the epic conclusion to a jury trial full of road rage and regret. The punishment phase kicks off with the state introducing the defendant's criminal history and revealing a troubling incident where he threw urine on another inmate while in jail. Then, in powerful testimony, the victim is recalled to the stand. He tells the jury about the permanent hearing loss and shattered teeth he lives with every day, and asks them to sentence his attacker to 40 years in prison. Finally, the defendant's own mother takes the stand to plead for mercy before the defendant himself asks for a second chance on probation. The jury must decide a just punishment, and we're there when they deliver their verdict. And it all starts right now.
Good morning. Let the record reflect the jury seated, state's attorneys present, defendant, and defense counsel are present. Mr. Coleman, does the state wish to make an opening statement?
No, Your Honor, state would waive the opening statement.
All right, you may call your first witness.
Before I do that, Judge, I reoffer all of the evidence from the guilty phase into the punishment phase, Judge.
All right, that's granted.
State this time would call Michael Ponder. Hey. It is not being accepted.
Thank you. Good morning, sir. Please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you, sir. You can have a seat. You may proceed.
Make sure that your rank right, Mr. Ponder. What is your rank?
Captain.
Yeah, Captain Ponder. Thanks for being here, Captain Ponder. I know we reached out to you somewhat on short notice. Please state your name, full name for the court reporter and for the ladies and gentlemen of the jury.
My name is Captain Michael Ponder.
And how are you employed, sir?
I am the captain of the Jefferson County Sheriff's Office.
Okay. And your duties as the captain at the Sheriff's Department, what does that include?
I am the custodian of records. I'm responsible for keeping all of our records for the state required time.
Very good. And would that include or encompass the booking records?
Yes, sir.
I'm sure the jurors are familiar with that term booking, but let's just play it safe. What does that mean? When someone is arrested and brought to the jail, in summary, what happens?
When anyone is brought to jail, we collect all of their personal identifying information and all the causes for them to be confined in the jail.
All right. And that personal identifying information includes date of birth.
It'll include their name, date of birth, pictures.
Photos of actual photos
of the individual, yes,
of the individual as well. Do you have any reason to believe that process did not take place with the defendant here, Asa Jones?
No, sir.
In fact, would you bring with you some records related to Asa Jones?
Yes, sir.
May I approach the witness, Judge?
You may.
And see those, please. Are these records? I think what I want to just focus on is this first page. I'll let you keep that. This page. Is this a true and accurate copy of the records that are maintained in the ordinary course of business by the Jefferson County Sheriff's Department?
Yes, sir.
All right. For the record, I am going to mark this, Judge, as State's Exhibit 74. And I will tender to defense counsel for his inspection.
Okay, there are a couple questions, Ron.
Yes, sir.
Good morning. Did you generate this report?
No, sir.
You're just the custodian of the record.
Yes.
You have no knowledge of how this was entered or anything to do with this State's Exhibit 174?
No, I'm aware of how the process we use when it's done, but I did not create that myself.
But you did not do this. Subject to hearsay, Your Honor, I have no objections to it. If he's going to testify to any personal matters in this document.
Just let me, if I may, just follow up with the full predicate on that. Whoever entered these entries on these or for these records would have done it at or near the time when that information was provided to them, correct?
Correct.
And it would have been done and maintained as part of the ordinary course of business for the Jefferson County Sheriff's Department, correct?
Yes, sir.
That's I believe I've laid the proper foundation of preparation.
I still have the same objection, Judge, if he's going to talk in reference to knowledge of that information. I have no objection that that's a record that's kept in the normal course of business. But anything behind that, I object.
Any hearsay in a business record is an exclusion or exception to the hearsay rule.
I guess I'm not understanding the objection because you're not objecting to the piece, the
I'm not
actual
objecting
document
to-
coming into evidence.
Objecting to any of the facts or circumstances surrounding the entry of that information, that he's going to testify as to any knowledge of what the circumstances were, book in, or anything about if there was a charge or anything like that behind those records. I'm not objecting to that.
So no objection to say 74.
Well, it's subject to if he's going to go into. the
Well, then
contents of-
object if there's a question. I just need to know if there's an objection to 74.
No, I told you there was no, yeah, Judge.
That's what I need.
No
I'm
objection to
confused.
The document. itself.
Okay, 74 is admitted. And then if there's another objection, if you ask a question, just make it then so the record's clear.
Thank you, Your Honor. Captain Ponder, for this individual, what's the name listed in that record or document for him?
Asa Joseph Jones,
Okay, and a date of birth for that individual?
February 16th, 1999.
And is there a photo included for that individual?
Yes, sir.
Do you see someone in this courtroom today that resembles the individual depicted in that photograph?
Yes, sir.
Would you please point to him and identify him by an article of clothing that he is wearing?
So gentleman, I believe it's gray shirt.
Your Honor, I'd ask that the record reflect that the witness has identified the defendant.
The record will so reflect.
That's all the questions I have. I'll pass the witness.
Thank you, Mr. Coleman. Any questions, Mr. Coleman?
No questions.
Any objection to Captain Ponder being excused?
Stays under the rule. Judge.
Thank you, Captain Ponder. And you are placed under the rules to not discuss anything with anybody until the trial's over.
Yes, sir.
All right, thank you, sir. You may call your next witness.
The state calls Steve Hinton.
That's right. They said
We need to take the witness out of order.
if he's walking down with him, wait just a second.
State calls Sergeant Marlon Carter.
Okay. Good morning, sir. Please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing or this trial will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. You can have a seat.
Sergeant Carter, would you please state your full name for the court reporter and the ladies and gentlemen of the jury?
Marlon Carter.
And Sergeant Carter, how are you employed, sir?
I work at Jefferson County Correctional Facility.
And were you working back at the Jefferson County Correction? Well, in what capacity do you work there?
I'm a sergeant, a supervisor at the correctional facility.
Okay.
Can you pull that microphone down just a little bit? There you go. Thank you, sir.
And were you working there back on March the 21st of 2026?
I was.
And at around 12:30, what, if anything, caught your attention? And I want to be careful not to get into hearsay. In other words, what someone other than the defendant said. So, but describe to the jury what caught your attention.
I was advised by my fellow officers that an inmate was refusing to go back into the holding cells at the recreation yard.
Can you stop there? Did you make contact with that individual, that inmate that was refusing to go back into the holding cell?
I did.
And again, I don't want to get into what he told you because it's hearsay. But as a result of what he told you, did you then go and pull Asa Jones out of his cell?
I did.
And did you bring Asa Jones back to your office?
Yes, sir, I did.
And did you speak with Asa Jones about whatever issue it was that the other inmate had, which was causing him not to want to go back to his cell?
Yes, sir, I did.
Now, you certainly can say what the defendant told you. That's not hearsay. So at that point, what did the defendant tell you?
that he admitted that he had thrown a substance on Mr. Franklin
A substance believed to be what?
to be urine.
Okay. And unfortunately, is that a common or uncommon occurrence out there at the jail?
It is a very common occurrence.
Is there like a term that's referred to that?
Dashing.
Dashing.
Yes, sir.
It's not uncommon for inmates to dash other inmates. And it's not uncommon for the inmates, unfortunately, to dash correctional officers. Correct?
Yes, sir.
To dash a correction officer, that is it's a felony, if not mistaken, right?
Yes, sir.
And that's not limited to just urine, unfortunately, right?
No, sir.
Other bodily things, correct?
Yes, sir.
All right, but with regard to other inmates, at a minimum, is that a violation of the jail rules or guidelines out there at the jail, right?
Yes, sir.
Something for which the defendant would have known or defendants are advised is not allowed or not appropriate, right?
Yes, sir.
Okay. Pass the witness, Mr. Chairman.
Thank you, Mr. Coleman. Mr. Burbank?
Yes. Good morning.
Good morning.
Okay. You can remember, Deputy, what cell or what dorm was Asa in?
I do not recall at the time.
Okay, how many people were in that dorm approximately?
It was on the recreation yard, so the whole population was, usually the dorm holds one to 48 inmates, so the whole population was outside.
Now, when you say the whole population, the whole dorm population?
Yes, sir.
Okay, so 140, 150 people,
No, sir, just that 48 inmates.
48 inmates.
Yes, sir.
Okay, I thought you said 140. Okay, so 48 inmates in a dorm.
Yes, sir.
In the dorm, you take the dorm out at the same time into rec.
Yes, sir.
And rec is, let's get them outside and whatever they want to do, exercise and things like that.
Yes, sir.
And this dorm, is it one big room?
Yes, sir. It's a holding, like a rec pen outside.
Okay, so it's a rectangle building and it has beds in it and bunk beds, right?
The fencing outside for.
No, I'm talking about the dorm.
Yes, sir.
You have the 48 people in one dorm, one big room, common bathroom,
Yes,
right?
sir.
And bunk beds.
Yes, sir.
And so they're all in there, right?
Yes, sir.
And these people that are in there, charged with all types of crimes,
Yes, sir.
offenses, right?
Yes, sir.
All walks of life.
Yes, sir.
They're kind of like in a cattle pen. I mean, they're all in one building and have to deal with each other 24 hours a day.
Yes, sir.
And I know this is a correctional facility, so I understand that. Now, you received information in reference to Asa and another inmate in reference to a conflict that started out in the rec yard, correct?
Yes, sir.
And you would agree with me that tensions usually do run high out at the jail facility, correct?
Yes, sir.
Because of the overcrowdedness, right? I heard the other day, I don't know if you heard it, that the sheriff said we may need an additional jail because they were going to be overcrowded. Did you hear that?
Yes, sir. I did.
Oh, okay. So your sheriff said, your boss said,
Yes, sir.
we're kind of overcrowded, right?
Yes, sir.
Okay. But in addition to that, you have 40-something men all together, all different walks of life that have to stay together, right?
Yes, sir.
And so conflict is common, isn't it?
Yes, sir.
People don't get along.
Certainly.
And what you heard, or excuse me, did you ever in your investigation look to Asa that Franklin originally or started, he had thrown something at him.
Yes, sir.
Right? So he threw something, he thought it was water, but he didn't know what it was, right?
Yes, sir.
And so in return, Asa threw something back at him, right?
Yes, sir.
And when you brought him out and separated the two,
Yes, sir.
right? You were called in, you brought him to another location,
Yes, sir.
right? And you talked to him, right?
Yes, sir.
Of course, now the other inmate wanted to press charges, right?
Yes, sir.
I mean, when he started it, right?
Yes, sir.
Okay, well, charges pressed.
I do not know.
Okay, but you didn't press any charges.
No, sir.
You didn't write a report that says, I'm pressing charges.
I added it in my report.
Yeah, but that you wanted to press charges.
Yes, sir.
That was it. And my question, Deputy, is, you didn't then follow up with a criminal offense and say, I recommend criminal charges against these.
I don't handle that department, and it goes to somebody else.
Okay. And so when you brought Asa in, he talked to you, right?
Yes, sir.
And he didn't try to say, I didn't do anything, right? He admitted to it, right?
Yes, sir, he did.
And he said the reason why was that somebody else had this other gentleman that he had conflict, ongoing conflict, I guess, with, that started about 2 weeks prior, correct?
Yes, sir.
Okay. And I guess it escalated.
Yes, sir.
And then after that, you brought him, who's Sergeant Granger?
Another supervisor on the unit.
Okay, why would you bring him to another supervisor?
To confer a good outcome of the situation.
Okay, so I mean, he then followed your orders
Yes, sir.
and went to wherever you said and talked to the other supervisor, right?
Yes, sir.
And then after it all was said and done, you sent him back to the door.
Yes, sir.
That was it.
And wrote a disciplinary case.
Yes, well, you wrote up, okay, well, did you put him in segregation?
No, sir.
Right. Did you take away his privileges, or is there any?
We did the disciplinary case, and the disciplinary board served him his disciplinary case.
Okay, but you don't know anything about the disciplinary case?
No, sir. I can't take processing that.
But you didn't segregate him, you didn't put him in lockdown or solitary or anything like that. You said, basically, you gotta stop this, whatever it is, and you sent him back to his door.
Yes, sir.
Thank you. Pass witness.
Thank you, Mr. Coleman.
Sorry, and I just want to clear up something. The defendant himself admitted that the substance that the other inmate threw on him was water, right?
Yes, sir.
All right, so he admitted that at some point prior to him throwing urine on this other inmate, the other inmate only threw water on him, correct?
Yes, sir.
All right, that's what it says.
Thank you. Anything else, Mr. Barbe?
Well, that's what he thought it was water, right? And he said, yeah, I think he threw water on him, right?
Yes, sir.
Okay.
All right, any objection to Sergeant Carter being excused?
Okay.
Thank you, Sergeant. You're excused.
State will try to call Steve Hinton again, Judge.
Investigator Hinton,
Investigator Hinton.
good morning. Please raise your right hand. You swear or affirm the testimony you're going to give in this trial will be the truth, the whole truth, and nothing but the truth.
I do.
Thank you, sir. You can have a seat.
Would you please state your full name for the court reporter and the ladies and gentlemen of the jury?
Stephen Russell Hinton.
And Investigator Hinton, how are you employed, sir?
I'm employed with the Jefferson County District Attorney's Office as a criminal investigator.
Okay, and prior to being employed with the DA's office, what is your background? Do you have other law enforcement background?
Yes, I have about 42 years of law enforcement experience.
Including what agency?
The Groves Police Department and the Jefferson County Sheriff's Office.
Okay. And have you had any training as it relates to fingerprint or fingerprint analysis?
I have, yes, sir.
And please tell the jury what that consists or consisted.
The District Attorney's Office sent me to a school in Garland, Texas. It was Texas Forensic Associates, where they went through a battery of training comparing prints, well over 1,000 of them for the week, to be proficient in identification of prints.
Okay. And also, in addition to going to your training, have you conferred with or had any additional guidance by other investigators in the office who've been identifying prints for some time, quite some time?
Yes, we use the ACE-V methodology and verified with Paul Arvizo, another investigator in the office.
The ACE-V methodology, is that just a kind of the technique or underlying method?
Yes, it's an underlying method we utilize to make the comparisons.
Okay, and just briefly, what does that mean?
It's to analyze, compare, and evaluate, and then we verify with another agent of greater experience, I guess you would say, to confirm that what I'm looking at is in fact the same thing that he sees or she sees.
And does that ACE-V methodology include looking for those points like the jury heard from the other ID techs previously in this case?
That's correct. Points or characteristics, however they want to call it.
Okay. I mean, and what is the point? What are we talking about there?
We're talking about either bifurcations, ending ridges, dots, deltas, whatever the actual print presents itself to.
Okay, and just to be clear and make a pretty good, the record better, I should say, fingerprints. I mean, we all think we know, we all have an idea of what they are, but essentially, how is a print left on? How does a print go from someone's finger or hand onto an object?
Scientifically, they're called friction ridge skin. They're located on the tips of your fingers, on your palms, as well as on the sole of your feet. That's the only three places they're located on a person's body. Oils from your hands, from your hair, from other things that you may get, you transfer a print to another object by touching it and transferring it to another object, which is either paper, glass, or something that would be something that would actually receive the print without too much distortion.
Have you ever known or heard of two individuals to have the same or exact same friction ridge scan or fingerprint?
No.
In this particular case, did you take what's known as an inked print from the defendant, Asa Jones?
I did this morning, yes, sir.
And what is an inked print?
It's where you apply ink to a friction ridge skin. In this particular situation, it was the right thumb, and then you transfer it to a fingerprint card for comparison.
And you kind of alluded to my next question. What, if anything, did you compare that ink print or ink prints to? What were you taking that print from him to compare it to?
To previous judgments from past history.
Judgments that resulted from previous convictions or adjudications of criminal offenses, right?
Yes, sir.
And those judgments or adjudications, they typically have prints on them that identify the individual who was convicted in that crime or adjudicated of that crime.
They do.
Sometimes it's fair to say.
Hold on that time. Can we approach Judge? Go on.
That's fine.
Oh, record for a second. They gave me notice. I just. Oh, the records. Oh.
We're talking about judgments. Judgments typically contain fingerprints. It's not unheard of for certain judgments to not have a fingerprint at all, correct?
Sometimes the way they store them, they pixelate them to the point you actually can't read them anymore.
And I was going to get to that, but you have heard that some jurisdictions, particularly with misdemeanor offenses, they don't even put a print on their judgments, right?
That's true. Yes, sir. Some of the rural areas.
Yeah. So there could be judgments without a print, and there could be judgments with either distorted or somehow an issue or defective print on it, right?
Unreadable print. Yes.
Unreadable print. And in those instances where there is no print, where there is a print that's unreadable, is it possible to use other identifiers to link an individual to that judgment?
It can be, yes, sir.
And we're talking about identifiers like date of birth or what's called a SID number, state ID number, that kind of thing.
That's correct.
In addition to the name that's on the judgment, correct?
Yes, sir.
Do you have judgments here today that you believe are associated with this defendant?
Yes.
Now, I'm sorry, Judge, may I approach?
Yes, sir.
I think what I'm gonna do is I'll mark this first. All right, Investigator Hinton, let's go through these one at a time. The first thing that I have marked is State's Exhibit number 75. Is this a copy of the inked print that you took from the defendant?
Yes, it is.
Okay, very good. Same, it looks to appear to be in the same condition as it was when you originally took that print.
It's identical, yes.
Okay. And we also have here some judgment information that has been marked as it will be 6, 7, 78, 79, and 80. 76 through 80 that I've marked. Now, the issue is it fair to say that when judgments are requested, they don't just, clerk's office doesn't just give us judgments, right? They give us a lot of other documents to go along with it, right?
The packet, yes.
And those documents are all certified together. So to remove them and separate them apart will be kind of like messing with, or kind of the argument could be made that they're no longer a certified document if you start separating them outright.
That's cool.
And I represent to you that there's an agreement between the parties here that we can now separate these. In other words, just take the judgments out. So I think that's what we'll do one at a time, okay? Let's start with State's Exhibit number 76 here.
Your Honor, if he just separates it out, I think even if he separates the document out, it's still a certified copy. He's not tendering a non-certified copy. Instead of going all through this, there are documents in there that have to be taken out. He just take it out and present it.
I'm good with that. If there's no objection to that, go ahead, Mr. Coleman.
At this time, the state office states 75 through 80. And I'm tendering to defense counsel for his inspection.
Objection states 75 through 80 concludes.
States 75 through 80 are admitted.
All right, investigator, I'll put these here so we can take them one at a time. Let's start with State's Exhibit number, well, let's do it for this order. Correct order, 76, 77, 78. You start with this one. All right. What is the cause number there at the top?
House number is 23 CCCR 2496.
And it's a judgment, correct?
Judgment of conviction, yes, sir.
For what offense?
Unlawfully carrying a weapon.
Unlawfully carrying a weapon, and that's a misdemeanor, right?
Yes, sir.
Okay. And what, if any, ways or methods did you use to link that judgment to this defendant? Well, let's start this way. What condition is the print or the fingerprint on that judgment?
The print was at extremely poor condition. It was pixelated to the form that you really couldn't read any characteristics or points from it. So he utilized the prints as identification.
All right, but nevertheless, it has a name, and the name on that judgment being
Asa Jones.
and it has a date of birth on that judgment, the date of birth being. Well, I separated the paper, the certification from its own certification. Investigator Hinton, before we go, so we're talking about the unlawful carrying of a weapon conviction appearing in cause number 23 CCR 2496. And your testimony was with regard to the print on that judgment. What condition was it in?
Yeah, it was a poor print, unreadable.
And were you able to use other identifiers to link this defendant to that judgment?
Yes, sir.
Those identifiers include what?
His name and his date of birth.
Okay. That date of birth being 2/16/1999.
That's correct.
And may I proceed with your search?
You may.
Is that consistent with the name and date of birth that appears in State's Exhibit number 74, the booking records for that defendant?
Yes, sir, it is.
And that particular judgment for the misdemeanor, was from, what's the date of the judgment, if you can find it there?
Date imposed is 8/7/24.
Okay, and what, if any, punishment did the defendant receive?
Shows 1 year probation.
All right, so he received 1 year probation on that unlawful carrying of a weapon in August of 2024. Let's move on to the next judgment. That was states, what was that marked as?
State Exhibit 76.
76. Let's move on to 77, please. What's the cause number that appears on that particular judgment?
It's going to be number 329698.
And that's what offense? What offense is that a conviction for?
It shows unlawfully carrying a weapon.
So we've got another unlawfully carrying a weapon from what's the date of that judgment? What date was it filed with the clerk if you can't find the date of the judgment?
August the 22nd of 22.
Okay. And what, if any, punishment did the defendant receive for that additional unlawful carrying of a weapon?
It shows 30 days confinement.
Okay. Let's move on to State's Exhibit number 78. What's the cause number for State's 78?
Number 312936.
For what offense?
It's going to be possession of marijuana, Class B.
And from what's the date of the judgment?
It's going to be November the 1st, 2016.
And what, if any, punishment did that defendant receive?
5 days confinement.
You know what? Let's back up to 77. I neglected to ask you with regards to 77. How did you link that to him, to the defendant? State 77 being that additional unlawful carrying of a weapon. Was the print good on that one?
Yes,
Did you use that to compare to your inked print?
to my known print, yes, sir.
What, if any, determination did you make?
That they are one and the same.
And in addition to comparing the prints, they also contain the same identifiers, date, alert, and the name of the defendant. Right?
That's correct.
Okay, all right, put that to the side. Let's get back to 78. The judgment for the possession of marijuana. I don't know if we established it or what, if any punishment did he receive for that?
5 days.
And how did you link that to the defendant?
That print was also of good quality, and I was able to make the characteristics comparisons and showed it to be one and the same.
Okay, very good. And in addition to the print comparison, I also had the same date of birth as the other judgments and as the booking records, right?
That is correct, yes, sir.
Now let's move on to State's Exhibit number 79. Is that cause number 327534?
Yes, sir.
And what offense does that refer to?
Unlawfully carrying a weapon.
All right, so third, unlawful carrying of a weapon.
Yes,
What, if any, punishment did the defendant receive for that offense?
it was 30 days confinement.
And did you, was the print of good quality and were you able to compare it to your known inked print?
Yes, it was good quality.
And what, if any, determination did you make?
That they are one and the same based upon the known print.
Very good. And lastly, State's Exhibit number 8. That a failure to ID judgment.
Yes, failure to identify.
And does that have the case number, cause number 313216?
Yes, sir, that's it.
And for the ladies and gentlemen of the jury, failure to identify, that is a criminal offense. Typically, how does that occur?
When he's encountered, he's asked for identification and they give false identification.
Encountered by law enforcement?
Correct.
Okay, all right. And that particular judgment, what, if any, punishment did this defendant receive?
It shows 1 year probation.
Okay, so another year probation, correct?
Yes, sir.
And what, if any, method did you use to link that judgment for the failure to identify himself to this defendant?
The fingerprint again was good quality to be able to make the comparison to the known print,
Okay.
as well as the name and the date of birth on the documents.
Very good. Just get these exhibits over there, Judge, and I'll pass through this.
All right, thank you, Mr. Coleman. Mr. Burbank?
Yes, Your Honor. These offenses that you just testified to, investigator, are all misdemeanors, correct? Correct?
That is correct, yes.
And the first one, this was, what year was that? Don't remember.
22 or 16, I'm sure.
I approached it. Yeah. And State's Exhibit number 76. That was in 24, correct?
Yes,
And he's got,
24.
he's on probation, correct?
Yes,
And 77, State's Exhibit number 77. That was in August of 22, correct?
that's correct. It's-
And when it says 30 days, does that indicate possibly to you through your experience that it appears he was represented by counsel, correct?
Yes, sir.
And that he was just time served? Is that what it appears to be?
It's a possibility, depends on how long he was
Right.
in the jail.
And that's not unusual.
Don't talk over.
I'm sorry, that's not unusual in a misdemeanor case, correct?
Sure.
Okay. And then, State's Exhibit number 28. I mean, excuse me, 78. What date was that on?
November the 1st, 2016,
Okay. And he got 5 days for that?
possession of marijuana, yes, sir.
And does that also look like a credit for time served, 5 days on a misdemeanor?
Could have been, yes, sir.
I just want to get it over with. He's been sitting in jail. You can answer.
Could have been.
Okay. Were some of these related from the same offense? You talked about a failure to ID. Was that related to another offense that you just talked about?
I think it might have been the possession of marijuana case.
Okay, so he possibly could have gotten arrested at the time and asked him for his name, and either he didn't give the right name or didn't want failure to ID, but that was all associated with the same case, correct?
I believe so, yes, sir.
Okay. And the same way with State's Exhibit number 79, which was, well, this is August of 22, right?
Yes, sir.
And State's Exhibit number 77. That's the same date?
Same date.
So he just took care of 2 cases at the same time?
It does appear that way.
Different cause numbers though, right?
They are.
Awesome. And there appears to be possibly that he was represented by counsel, right?
Yes, sir.
Under counsel's advice.
Right.
And then this last one, State's Exhibit number 80. That was the failure to ID, and that was the one that was, you said, went along with the possession of marijuana. That sound about right?
I believe so, yes, sir.
Okay.
1 year probation.
Prior to court today, in order to do your comparison, which is State's Exhibit number 75, which you identified as his prints. You did that here, did you not?
I did, yes, sir.
He was cooperative.
Yes, sir, he was.
and didn't give you any problems.
No, sir.
And at any time, do you have any knowledge in reference to all the exhibits here, 76 through 80? Did he ever deny any of the prior offenses to you?
No, I never did interview him.
No, but he never said that wasn't me.
No.
And he was cooperative in an identification, right?
Yes.
Yeah, and I say that because you went through an elaborate of how to identify him either through his date of birth, his name, or usable words, correct?
Yes.
I mean, he never said I'm not Ace Jones in this.
No. In fact, he signed the known card.
And it's safe to say you know nothing about the offenses that are in State's Exhibit 76 through State's Exhibit 80, do you?
That's correct. I'm just comparing.
Just comparing fingerprints.
Prints and identifiers to determine if they're one and the same.
Thank you, investigator. Passing.
Anything else, Mr. Coleman?
No, Judge.
Any objection to investigator being excused?
No, Judge.
Any objection? Thank you, sir. You can step down.
State calls Jody Roach. So recalls Jody Roach.
Good morning. In this road, you're still under your oath. You may proceed.
Thank you, Your Honor. Thank you. Full name for the report.
Jody Roach.
Jody, Ms. Roach, you work for the probation department, don't you?
Yes.
We made an effort to make sure that that wasn't put out there during the guilt innocence phase so that it wasn't prejudicial to the defendant, right?
Correct.
All right. Nevertheless, this defendant was being supervised by the probation department back on June the 12th of 2025, correct?
Correct.
For the offense of unlawful carrying of a weapon, right?
Yes.
Please tell the ladies and gentlemen of the jury the nature of his compliance with or non-compliance with the conditions of his probation.
Your Honor, I am going to object because there was prior testimony, it is hearsay, that she was not his probation officer. She was a supervisor of a supervisor. So it's based on hearsay.
I can lay a little bit of a predicate if you'd like, Judge.
Sure, go ahead.
You were not the actual probation officer that supervised this defendant, correct?
Correct.
But nevertheless, is it part of the duties of each individual probation officer to make entries or what some of us old school lawyers and old school probation officers refer to as chronos, right?
Yes.
It's essentially like notes that are put into the system of the database
Yes.
about the defendant or about certain events or activities in their case, right?
Yes.
And have you reviewed the chronos as it relates to this particular defendant and his community supervision?
Yes.
Okay.
I'm sorry, you can't object. It's like a police report. Another officer cannot testify as to the information of the report. She testified earlier that she had no knowledge of Asa Jones and that was not her supervisor.
So these are business records maintained in the ordinary course of probation department's business.
I don't remember what exhibit that was, Judge. And again, I object even to the business records of her testifying as to somebody else's information.
Sustained.
One of the questions I'd like to answer is about whether or not his probation is extended. That's not hearsay. That's represented by a document, an actual document, Judge.
I'll allow that.
In this particular instance, was this defendant's probation extended?
Not in the case I talked about yesterday.
Was his probation or a previous probation ever extended?
Yes.
Typically under what circumstances? So he's had 2 probations, right?
Correct.
Okay. Typically under what circumstances would a defendant's probation be extended?
Typically, it's to allow them additional time to be compliant with the terms of their probation. Mostly includes their court order fees, give them additional time to pay court order fees and or community service or anything else particularly that hadn't been completed.
The records as it relates to the extension in that probation, what do those records indicate? Not what somebody entered into a system or notes that somebody put into a system. What does the actual document indicate was the reason for the extension? If you know.
Again, objection, Judge, same thing.
Sustained. If someone else entered it into the record, then it's hearsay.
Is it a, with regard to the probation the defendant was on during the commission of the offense, the aggravated assault that we're here on, was it a prohibition, was it prohibited by his conditions of probation to not commit any other offense or violate any other laws of the state of Texas?
Yes,
And you are aware this jury has found this defendant guilty of aggravated assault, correct?
yes,
And that is a violation of the Texas law, correct?
correct,
And in turn, as such, it's a violation of his probation, correct?
correct.
That's what the judge.
Thank you. Any questions, Mr. Burbank?
I do.
Okay.
How long have you been a probation officer, ma'am?
Since 1998.
You have supervised, or have you known individuals that have been on supervision for aggravated assault?
Yes,
As a person that is under probation, they're under a number of rules, correct?
correct,
And it's under the supervision of the court. But you supervise a probationer for the court. Is that?
Yes.
Did I say that right?
correct,
Court puts them on probation and then says you supervise them.
correct.
In that supervision, there are a number of regulations or rules that someone needs to abide by.
Yes,
Agree with me?
yes,
Couple pages long.
yes, yes,
There's curfew.
yes,
There's no drinking of alcohol or drugs.
correct,
Staying away from certain people of bad reputations or things like that, right?
yes,
There's community service.
yes,
And felony community service usually is much more than misdemeanor, isn't it?
yeah, yes,
I mean, you're looking at several hundred hours of community service over the term. And misdemeanor is usually about 40 or 60, correct?
yes,
Sometimes.
yes,
Okay.
yes,
Now, the term of supervision, is it your understanding through your experience is that the jury in this case has found him guilty. And they have to assess if he's qualified for probation, to assess whether or not one either going to sentence him to penitentiary time for TDC time, or say, I recommend probation, right?
yes,
From you. And one of the requirements though is that if they do decide to put him on probation, they cannot assess a term of more than 10 years incarceration.
correct.
Now, I want to talk about that a little bit through your experience. The term that they put on, and in this case, it's a first degree felony, it's no less than 5 and no more than 10 years incarceration, right?
For probation,
For
Purposes,
probation.
yes.
If they assess that, then they can go ahead and recommend to the court the assessment of probation, correct?
yes,
Probation can be anywhere from, in this case, 5 years up to 10 years, correct?
correct,
But that is set by the court in reference to the length of time. Agree with me? They have to recommend it, but
yes,
the court assesses the
Yes.
length of time of probation.
yes,
Probation can be anywhere from 5 years to 10 years, right?
right,
And then subject to that, if he violates it within that period of time, then he's subject to whatever prison term they assess. For instance, if they assess 10 years and he violates any rules of probation, then he is looking up to 10 years in the penitentiary.
Yes,
Okay. Just as if it's 5 years, and he violates it, he's only looking at up to 5 years, well, which is the minimum, but which is a bad example. But he's looking at up for 5 years, correct?
correct.
Okay. So it's important that if he is considered for probation, that the term of prison can't be assessed more than 10 years by a jury.
Correct.
Okay. Also, with the rules of probation, there are also programs, correct?
Correct.
That the court can assess or probation can assess, right?
Correct.
They can send them to an ISF program. What is ISF?
It's an intermediate sanction facility. We have two types. One is a cognitive track, which helps with their criminal thinking errors. And then we have another track that addresses substance abuse.
Substance abuse. So if he had a problem with drugs, for instance, if this case was a controlled substance and he had prior controlled substances, that may be a program to say, hey, you might have to do that.
Correct.
There's also safety in that too,
Yes.
which is a lockdown facility and a state jail facility.
Yes.
Correct? Okay. And that's usually done by an assessment by the probation department to see whether or not a person needs help.
Correct.
And then you said one of them was cognitive,
Yes.
and that's basically is you're going down the wrong path. You need to get straightened out.
Correct.
That's a program. Is it like a self-help program or was it a lockdown facility?
No, it's locked down for
Lockdown?
yes, for 90 days.
And it could be whatever time, depends on how a person acts.
Correct.
If they abide by everything, it could be shortened or long, whatever it might be, correct?
I don't know about the shortened, but it can be extended.
It can be extended.
Yes.
And the purpose of that is saying you're getting your second chance or you're getting, you're not going to the penitentiary.
Correct.
So we're trying to help you make the right choices.
Yes.
I had also heard that, and I was wondering that probation also tries to help with employment.
Correct.
In fact, did you ever hear of people that if they wanted to become a truck driver, they send them to LIT through some programs
Yes.
or processing or anything like that, trying to help them along, correct?
Correct.
And do you see that in your experience, that sometimes employers don't want to take a chance with somebody on probation?
Yes.
And so you try to help them get over that hurdle and try to pick an employer that will give them a second chance?
Yes.
Through your experience, Ms. Roach, does a lot of the problems that probationers have is money, trying to get a job, maintain jobs,
Yes.
to try to get, I guess, back on their feet again and try to be productive?
Yes.
And have you seen that if that doesn't happen, they start running into problems, don't they?
Yes.
They have families and things like that.
Yes.
So there's a whole bunch of regulations and rules that if somebody is granted probation, that they would have to abide by over whatever period of time. In this case, no less than 5 or 10 years.
Correct.
Okay. If they violate, then does it usually come through the probation department? The violation?
Yes.
I mean, if they get arrested again for another offense, you get the police report, or you get notified by the jail, he's back in custody again.
Yes.
If he's not complying with community service or not going to the counseling or programs or whatever it might be, that's generated through your office.
Yes.
And then somewhere down the line, there's an administrative hearing,
Yes.
and then that recommendation is then sent to the judge.
Correct.
And when you send it to the judge, Is that to determine whether or not they need to file a motion to revoke this
Yes.
person's probation?
Yes,
And then the judge says yes or no.
correct.
The judge then puts him back usually in custody, either holds him in custody or lets him set a bond, but there's a hearing in front of this court.
Yes, yes,
So if somebody is given probation, stands here and is given a second chance, and then he has to come back in front of this judge if he doesn't take advantage of that second chance.
yes,
And this judge would have to decide what to do with the person.
yes.
Have you, in your experience, have you had probationers that have used deadly weapons on probation?
Yes,
Have you had probationers that have been given second chances, like 2 probations or so?
Yes.
Does it make a difference in reference to a probationer's age?
no,
And they would have to report how often?
it depends on what level of probation they would be on.
That's what I wanted to get to. There are different levels of probation.
Yes,
And what are the levels?
you have the low risk, a moderate risk, or a high risk.
Okay. And don't you have like a 0 tolerance too?
Yes,
Which is that what you call the high risk?
yes,
Okay. Low risk is we think everyone's going to be compliant, the probationer is going to be compliant, and he may report or she may report once a month.
Correct.
or As long and comply with either writing in or calling or doing whatever, and you think they're going to complete it.
yes,
If you think that a probationer is going to maybe a little bit of attention getter or you need to keep track of them. So then it kind of goes to medium high.
yes.
Tell me a little bit about 0 tolerance through your experience in reference to probation.
Zero tolerance is usually, the judge usually sets that, and mostly because they've been in front of her on some allegations. And, his probation may be reinstated, and zero tolerance means don't mess up. You do anything wrong, you're coming back to court, possibly facing going to prison.
I mean, it's like if you test dirty, it's a violation. I'm ordering you bring him back to court.
Yes,
If he doesn't show up, if he doesn't comply with community service or anything within your multitude of rules, it's 0 tolerance. You didn't do it. Back in front you go.
yes,
And through your experience, have there been many people on 0 tolerance?
yes.
Pass witness.
No further questions for Ms. Roach, Judge?
Thank you. Any objection to Ms. Roach being excused?
No.
Thank you, ma'am.
Thanks.
Mr. Coleman?
State calls Hunter Freeman or recalls Hunter Freeman.
And Mr. Freeman, you're still under oath from before.
Yes, ma'am.
Have a seat. Go ahead.
Thank you, Hunter. Thank you, Hunter, for coming back. Just for the record, state your full name, please.
Hunter Allen Carl Freeman.
You didn't want to be here this morning, did you?
No, sir.
In fact, you told me you didn't want to be here.
No, sir.
Why not?
It's a little hard to talk about sometimes.
What makes it hard?
Just everything, bringing it back up. Just after a whole year, you tend to kind of put it past you just a tad bit, or try to at least.
Have you been successful in putting it behind you?
No, sir, not really.
In what ways does this, what happened to you, affect you and your life?
It's hard to sleep sometimes. Constantly remember the gunshots and everything. We're hearing in my ears at least 3 or 4 times a day. I can't hear out of my left ear. in there at all. I still do have clear hearing, but it's muffled. You can just tell the difference between your left and right side. My teeth, they tell me I can never have a full set of teeth again, most likely, not unless they do some side of more surgeries, and it's just it's still hard to eat sometimes. Can't eat certain things, whatever, just because of how sensitive everything is.
You understand this jury's tasked with assessing what they consider to be the appropriate punishment for this defendant for what he did to you. You understand that?
Yes, sir.
You understand they've got a really wide range to choose from, anywhere from letting this defendant walk out of this courtroom with a piece of paper and promises what they call probation, all the way up to 99 years of life in prison. You understand that's on the menu for this jury, correct?
Yes, sir.
Have you given some thought as to what you think justice would be and what you would ask this jury to assess in the way of punishment?
Yes, sir.
And what would that be?
Be 40 years, sir.
You don't reach that, or you didn't reach that conclusion lightly, did you?
No, sir, not really.
You gave it some thought?
Yes, sir.
Why do you say 40 years?
I don't want him to go to life forever. I don't want him to be in prison forever. Everyone makes mistakes, sir. I do understand that. But also what he did was wrong. And I just don't think he should be able to walk away from it either.
I mean, you've got to live with those memories for the rest of your life, right?
Yes, sir.
You've got to live with your hearing loss for the rest of your life, right?
Yes, sir.
And you've got to live with the issues with the loss of your teeth and not being able to enjoy food and a meal as a result of losing your teeth. You've got to live with those consequences for the rest of your life, correct?
Yes, sir.
That's the way it's changed.
Thank you. Any questions?
John. Again, good morning, Mr. Freeman.
Good morning.
40 years. Let me ask some questions.
Go ahead, sir.
Mr. Freeman, if you were sitting there and Asa was sitting there and Asa was asked, what do you think the appropriate punishment might be? Okay. And Asa said 40 years. Okay, 40 years. How old are you?
23.
63 years old. And this is based on testimony yesterday from you that said, I caused it, right? You testified to that. So you have to answer.
Yes, sir.
I taunted him. Remember
Yes, sir.
saying that? I said, come on, do it.
He couldn't have heard that statement, no, but yes, sir.
But you said that,
Yes, sir.
okay? And you said, I wasn't going to back down because that's how I wasn't taught.
But I did back down, sir.
No, but did you testify to that?
Yes, sir.
Okay. And so with that being said, and that belief, 40 years,
Yes, sir.
another individual that did that and said that, which was you, and he reacted to it.
Yes, sir.
Nothing further.
Mr. Coleman?
Hunter, are you on trial here today?
Yes, sir.
Sir,
Yes, sir.
Asa Jones is on trial for shooting you in the face, right?
Yes, sir.
Could you in any way on God's green earth have envisioned that when, regardless of how that road rage began or started, or who cut who off first, is there any way you could have envisioned that this defendant would pull out a gun and shoot you in the face?
No, sir, because I had one on me myself and I did not even think of even reaching for it.
Thank you. I'll pass.
Two last questions. This started approximately 2 to 3 miles before an actual shooting. That's what the testimony indicates, right?
Yes, sir.
So for 2 to 3 miles, you had a chance not to cause it, not to taunt him.
So did he, sir.
Okay. Not to taunt him and not to just stay there because no one was gonna do that to you. Right?
Yes, sir.
I have nothing for them, Judge.
Thank you. You can step down here. Any other
State
witness?
Texas race judge.
Thank you. Mr. Burbank?
I call Ace's mom.
What's the name?
I told you I can't because I forgot.
Okay.
He's outside, Judge.
Good morning, ma'am. Good morning. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this trial will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can have a seat. And if you'll just do your best, kind of pull that microphone over, make sure you speak loudly and clearly so everyone can hear you. Also, if it's a yes or a no question, be sure to say yes or no, not just a head nod or an uh-huh, so the court reporter can take everything down.
Yes.
Thank you. You may proceed.
Please, for the record, state your name, please.
Karen Denise Spencer. Karen Denise Spencer.
Spencer?
Mhm.
I apologize for not knowing or remembering your name,
It's okay.
but I drew a blank. Ms. Spencer, are you Ace's mom?
Yes.
You know that this jury now has convicted your son of aggravated assault in
Yes, sir.
reference to the incident that happened on East Texas. They now have to try to determine what punishment might be appropriate. You
Yes,
understand
sir.
that? Now's our time to kind of talk about Asa. Okay. How many other children do you have?
4,
Okay, and how old are they?
31, 30, Asa 27, 25, and 22.
And did they all live together at one time?
They all grew up together. I was a single mother.
And fathers, was Asa's dad around?
No, sir.
Where was Asa's dad? Do
No
you know?
clue. No clue.
No clue. Never had anything to do with him.
No, sir.
Did he ever have a father figure in his life that he could rely upon like a dad?
Well, I have several brothers.
Okay. Some of your brothers, did they go to the penitentiary?
Yes,
So maybe not very good role models.
correct.
Okay. What part of town did you grow or did you reside in?
The North End.
North End.
Yes, sir.
And we had testimony from a police officer here that knew Asa in school. What elementary school and middle school did he go to?
French, Caldwood, French and Caldwood.
Okay. And then middle school, is that
Alston and Vincent.
okay? After he finished middle school, what high school did he go to?
Central.
Central. Somewhere in Central, did he graduate?
No, sir.
How far did he get in school?
The 10th grade.
Okay. He was still living with you.
Yes, sir.
When he dropped out of school, did he just sit around or did he get a job?
Oh, no, he always had a job.
Okay, and tell us what type of work that he did.
Well, from maybe 15 to about 23, maybe, he worked at a convenience store. It was a family-owned convenience store.
Okay,
And then he worked at Popeyes. He worked at Focus, which was like a call center or something.
is that the one on Lucas?
Yes, sir.
That the old Lucas and
Concord, yes, sir.
okay. I worked there. Okay, so he always had some type of trying to make a living.
Yes, sir.
With his money, did he help out with the house?
Oh, very free-hearted. We wouldn't have on bills, or if I told him that a bill needed to be paid, he paid it because I was a worker as well.
Did he get along with his siblings?
Oh, very close.
He hasn't been perfect. He had some run-ins with the law with misdemeanors, some guns and this and that. Did Asa ever have an incident where he had been shot?
Yes,
Okay. And when he got shot, was it at his house?
yes.
And was he doing anything wrong or was he just shot?
Well, not to my knowledge, he wasn't doing anything wrong,
Okay,
but, the house, I don't know if it was, I'm not really sure what happened in the situation, but the house did get shot up. And he was hit with, I think, 2 bullets.
okay. Just kind of like standing around.
Yeah. Well, no, actually, he was in the bed. It happened at 4 in the morning.
So he was in his own bed.
Yes.
And did that affect him?
I'm sure.
Do you think he got hit with 2 bullets?
Mhm.
How long ago was that?
2020, I want to say.
2020.
Yes, sir.
Okay. Does he have any kids?
2.
2?
Mhm.
And where do they reside? What's
With their
it?
mom.
Huh?
With their mom.
In Beaumont?
Mhm.
And as
Okay.
grandma, what type of interaction do you see between your son and his children?
Oh, we have a very pretty good relationship with the grandbabies.
So is he actively involved?
Yes, sir. And so is me and my daughter.
Going to any of them at school?
Yes, sir.
Does he go to school for functions?
Yes, sir.
How about extracurricular activities?
Every once in a while. Every
Okay.
once in a while.
Does he provide for his kids?
Yes, sir. And whatever he can do, me and my daughter does.
Okay. Unlike his dad, you think he possibly learned that he didn't want to be like his father?
Yes, sir.
So he's been active with his daughters.
Yes, sir.
We had heard testimony that he waited till after Father's Day to turn himself in because he wanted to spend time with his daughter because he knew possibly he was going to get arrested.
Yes.
Did you know that?
Yes, sir.
And did he actually spend time with his daughter?
Yes, sir.
Has Asa had your support since this incident?
Yes, sir.
And his family, I saw his aunt sitting back here. Is that your sister?
Yes, sir.
Y'all have family support?
Yes, sir.
Okay. Ma'am, if you were sitting there now and there was a person sitting here that was involved in an incident similar to what we had here today, that is driving along East Tex Freeway, leapfrogging a road rage, but ultimately ended up with somebody sitting here shooting into a car at least 6 times and striking one of your children. And thank God not dead. And you were sitting there and you were asked, what should be done to that individual? What should be done to that individual that did that to your child? Tough question, isn't it?
It is.
Can you see both sides?
I can't.
What's your thoughts?
I know Asa made a bad choice. I do. But to hear the victim say what he did, and I'm not saying what my kid done was right, but I feel like both parties should be,
Some type of responsible.
yes.
You may not agree with their decision, but this is what we asked them to do, right?
Mhm.
And you respect
Yes,
it,
sir.
right?
Yes, sir.
Okay. So what type of punishment do you think he should get?
I mean, I seen the guy ask for 40 years. I don't think that Asa should get 40 years. The victim. I don't think Asa should get 40 years. I do think that he should get punished, but I do not think 40 years.
Are you asking this jury to consider what I call the totality of the circumstances? That is everything that's involved in this case.
Yes, sir.
and come up with a punishment that they feel is just.
Yes, sir.
You would agree that there were two parties involved in this, correct?
Yes, sir.
It wasn't just like someone walking up to a convenience store and robbing or meant to go out and do something.
Yes, sir.
I say robbing or theft, right?
Yes, sir.
And you asked the jury to take that into consideration,
Yes, sir.
that it was two parties and a bad choice.
Yes, sir.
Pass the witness budget.
Thank you, Mr. Coleman.
Good morning, Ms. Spencer.
Good morning.
I'm so sorry that you have to be here. I'm so sorry that we have to meet under these circumstances. I just have a couple, two, maybe three questions for you, please. You understand and you testified that Asa grew up without a father figure, but you understand that many people grew up without father figures and they don't end up shooting other individuals in the face. Is that fair to say?
Oh, yes, sir. I grew up without a father.
Okay. And I want to piggyback on what Mr. Burbank was asking you with regard to the appropriate punishment in this case. And it's just quite simply, I just want to ask you, if someone shot Asa in the face, would you want them to walk out of the courtroom on probation?
I mean, honestly, I wouldn't wish 40 years on anybody, even.
I understand, Ms. Spencer, but my question is a very pointed question. Would you want the person that shot your son Asa in the face to get probation?
Maybe.
You can envision a situation where if they shot him in the face, that you would be okay with them getting probation, yes or no, Ms. Spencer?
Yes.
Okay. Nothing further, Judge.
Thank you. Anything else?
No, yeah.
Thank you, ma'am. You can step down.
Thank you.
All
Asa Johnson.
right, Mr. Jones, come back up. And Mr. Jones, you're still under oath as well. You can have a seat. You may proceed.
Asa,
Yes,
I
sir.
know that you were down, right?
Yes, sir.
And upset in the sense of you've been convicted now, right?
Yes, sir.
You told your side, right?
Yes, sir.
And you still believe in what you said and what happened?
Yes, sir.
We talked a little bit, and did we talk about that we may not agree with the jury in the decision,
Yes, sir.
but just as I told you, do you agree that you respect their decision because that's what we asked them to do?
Yes, sir.
Okay. And that's like life, isn't it?
Yes, sir.
Sometimes people agree, it's easy, and sometimes it gets difficult, doesn't it?
Yes, sir.
Right now, you're in a difficult part, aren't you?
Yes, sir.
They're going to decide what to do with you. We heard testimony from your mom that how old were you when you were shot while you were sleeping in your bed?
I'm like 20.
20? So you didn't even know what was going on.
No, sir.
And were you shot once or twice?
Twice.
Did it cause fear?
Yes, sir.
Were those people ever arrested?
No, sir.
Did you wish they were arrested?
Yes.
Okay. During this period of time, your mom said you were employed.
Yes, sir.
And what she said in reference to what you were talking about, what she was talking about in places that you worked, is that true?
Yes, sir.
And that you always work.
Yes, sir.
And you worked starting at 15,
Yes, sir.
and you helped your family out?
Yes, sir.
Okay. When you were working, why were you working?
Why was I working?
Yeah, why were you working?
Help my mom, really. Yeah, I really didn't much care about having money. I just really wanted to help my mom.
Well, You're 27?
Yes, sir.
Do you ever dream?
Dream?
Yeah, dream.
Yes, sir.
You ever dream of what you might want to be when you're,
Yes, sir.
I mean, you're getting old, not as old as me, but you're getting old.
Yes.
What do you want to be? What did you want to be?
But I wanted to be
Yeah,
growing up, basketball coach, something like that. You know,
you like sports?
yes, sir.
Want to be a basketball coach? Okay. How about working?
Working.
I guess basketball coach is working.
Yeah,
but-
but as far as working, it really didn't matter what I did. You know, I just like to work just so I can help my mom, no matter what it was,
Help family.
basically.
Tell me about your 2 kids. How old are they?
6 and 7.
And the 7-year-old's name?
Chloe,
All right. And the 6-year-old's name?
Lakin.
When you had kids, I guess you were kind of young, 20 years old, 21 years old.
Yes, sir.
How did that make you feel?
I just wanted to be a part of their life because I never had a dad. So, you know,
How did you take it when you heard that you were going to be a dad?
I was excited.
You were young.
Yeah. Yes, sir.
You didn't finish high school.
No, sir.
You know, one of the things if the court was to consider that steer was consider probation, you're going to have to finish high school. I can tell you that's probably going to be a requirement.
Yes, sir. I was in the process of getting my GED though.
You were.
Yeah.
How
Yes, sir.
far are you away from it?
Well, I was in the process.
Okay.
Of course.
Was this before you were put in jail?
Yes, sir.
So when do you think that would have happened? Would you have gotten it?
Yes, sir. Most definitely.
Okay. And why did you think that a high school diploma was a good thing?
High school diploma.
Yeah, graduating from
That's
high school, a
that-
GED. Why is that a good thing?
That's just something important that you like an achievement that you should want to achieve in your life.
You want to be somebody.
Yes, sir.
You think it would open up doors?
Yes, sir.
After you got high school, if you got a GED, would you have tried to go on to either college or some type of processing 2-year something to even better yourself more?
Yes, sir.
You have 2 girls. You've been in some minor stuff, misdemeanors, marijuana and guns and stuff like that. What kind of example do you think you are to them sitting in county jail, not being a part of their life?
That's a bad example. It's like I made a promise to my daughter that I'd never leave her side, you know, and I broke that bond by making a huge mistake in my life, you know.
During questioning yesterday in reference to when Mr. Coleman was asking you questions. One is that, are you sorry for what happened?
Yes, sir, 100%.
You still believe in what happened and what you testified.
Yes,
You're
sir.
not changing the story.
No, sir.
Are you sorry of the outcome?
Yes, I am.
But you really didn't know what the outcome was going to be at the time you did it, did you?
No, sir.
But you know it's kind of stupid afterthought.
Yes, sir.
Did you ever intend to hit Mr. Freeman?
Not at all.
But you realize when you fire a gun,
It's a possibility.
so I guess the question would be, and I would anticipate possibly, the question once I sit down is, one of your daughters was traveling down East Texas Freeway. Somebody came alongside them, road rage or not, back and forth, wanting to cause it or taunt them. And they shot. Went through one side and out the other. Now we're sitting here in front of the jury in reference to punishment. The person who did it, sitting here. What punishment? do you give that person?
I mean, honestly, in my honest opinion, I feel like some people just deserve a second chance. You know, people make mistakes in their life. You know, some people just need a second chance to better themselves. You know, see how to say this. No matter the circumstance, you know, some people just need a second chance to reflect on what they did to know, like, well, I don't want to go back down this road, and I know what the outcome would be if I do this, so I don't want to make that mistake again in my life.
You know, I know when I sit down, here's some of the questions I anticipate you're gonna ask or are gonna be asked. Starting back in 2026, 2016, excuse me. You were arrested for UCW, right?
Yes, sir.
Given a year's probation. Why didn't you learn your lesson then? I know it's just a misdemeanor, and now you're in the big times. This is a felony, first degree. Now, you're looking at up to life in the penitentiary. Why didn't you learn then?
I wouldn't necessarily I didn't learn. It's just with my house being shot up like that, I feared for my safety. I just wanted to protect myself and my younger sister and my mom. So I don't know who shot me and why my house was targeted. So I wouldn't necessarily say I didn't learn because I did learn from it. You know, and them charges, it's really not just. I just was in possession of a gun. I never committed a crime or anything like that. So, but I did learn from my mistakes. I learned from all my mistakes.
You know, carrying a gun is a crime.
Yeah, it is a
You are
crime.
convicted of it.
It is.
So back in August, you had a couple of them, which were the same time. Possession, I believe. UCWs. How come you didn't learn then? I know it was another misdemeanor. How come you didn't learn then?
I wouldn't necessarily say I didn't learn. I just was in fear. I was for my safety wise, just overall safety wise.
And when this happened back in June 12th, 25, you were on probation.
Yes, sir.
You were under the rules. You heard Miss Roach. She wasn't your probation officer. You were under the rules. Right?
Yes, sir.
Second chance. Let me ask you this, Asa, and it may seem simple. When you left downtown on the 12th and were heading back up north of Tram Road, was it your intention to get into road rage?
Not at all.
Was it an intention to pull out your gun and if you feared for your safety or not feared for your safety or whatever, to shoot?
No, was my intentions.
It happened in the heat of what was going on.
Yes, sir.
Did you realize that if you were 5 minutes or a minute before or after, this probably you wouldn't be sitting here?
Say it all the time. I say 10 seconds.
If this jury was to consider probation, there's going to be an awful lot of rules and regulations, okay?
Yes,
In
sir.
reference to this. Do you think you can do it?
Yes, sir.
You were on probation when this happened,
Yes, sir.
okay? But now, instead of getting your 30 days or 50 days if you violated it or 180 days, whatever it is, you'll be looking at up to 10 years in the penitentiary.
Yes, sir.
Who in your family went to the penitentiary?
Uncles, cousins.
What'd they go to the penitentiary for?
I'm not sure on the charges, but just know they
How long have they been in?
years.
Huh?
Years. At a
Years?
time.
You look up to them?
Yes, sir.
Well, how do you look
I
up
did.
to them when they're sitting in TDC?
Well, at a point of time, I did.
You want to have a cell with your uncles?
Have a cell with them?
Yeah, have a cell.
No, sir.
Be in the same unit.
No, sir.
You think that maybe you could correct this?
Yes, sir. I'm all about breaking on generational curses.
Generational curse.
Not a curse, but like a
How about-
recycle thing, like, you know,
How about breaking your bad decisions so that you don't take the white bus to Huntsville?
that as well.
You asking this court or this jury to consider probation?
Yes, I am.
And you realize that if you do violate, you'd be here, and this judge has listened to this testimony.
Yes, sir.
And do you know what the outcome would be if you violated, if they determined to give you probation? Do you want to take odds of what the outcome would be?
Up to what the case holds.
Yeah, you want to take a bet now if they were to give you probation? Let me answer it for you. 10 years. Not even in consideration. You realize that?
Yes, sir.
What have you done in the last 10 years in your life? How many birthday parties have you gone to?
Quite few.
Christmases,
Quite few.
4th of July's. We just did 4th of July.
Many.
You realize that if you were in the penitentiary for 10 years, these are everyday things?
Yes, sir.
And to Mr. Freeman, are you sorry?
I am very regretful. I'm just glad he's alive and he's okay today. Sincere from my heart, I do apologize for what happened.
Pass witness.
Thank you, Mr. Coleman.
Thank you, Your Honor. Just got a few questions for you, Mr. Jones. Maybe we can just kind of get through this as quickly as possible. Are you saying to this jury that the fact that you grew up without a father, the fact that you've been shot before, those are the reasons why you shot Hunter Freeman back in June of 2025?
No, sir, that's not the reason why.
Okay, thank you. Are you saying that this jury should feel more sorry for you than they do for Hunter Freeman?
Not at all.
Okay. You don't have any issues with your hearing, do you?
No, sir.
You don't have any issues with your teeth, do you?
No, sir.
But you understand that Hunter Freeman would have those issues for the rest of his life, right?
Yes, sir.
All right. Now, you have been convicted, albeit of misdemeanors. I will concede they were misdemeanors of 3 separate unlawfully carrying of a weapon. Let's start with the first one in 2016, I believe it was. No, 22. You had 2 of those in 2022. The first one in 2022, what kind of weapon was it? What kind of gun was it?
A handgun.
Do you remember the brand? Was it a Glock or?
I don't remember the brand.
Okay. This handgun, where'd you get it from?
Out the streets.
Who did you get it from off the streets?
I don't recall.
Because you used that term yesterday. I mean, I'm a little baffled by this term off the streets. I mean, you're telling me like Dowling just pops up a gun, or Concord pops up a gun and gives it to you? Or are you saying that there's an individual in the neighborhood that provides you with the gun? Is that what you're saying?
It's an individual. I just don't recall who.
Okay. Let me ask you about that second UCW, that second possession of a firearm in 2022. What type of gun was that?
A handgun.
Do you remember the brand?
No, sir.
Did the streets give you that one too?
Yes, sir.
You don't recall who gave you that one?
Not at all.
All right, let's move on to the 2024 unlawful carrying of a weapon. You know the question I'm going to ask. Where did it come from?
Streets, and I don't recall who I got it from.
That's unfortunate. That is very unfortunate that you don't recall any of that. Let's move on. You understand that you have, by the decisions that you've made, put yourself, and by virtue of those decisions, your daughters in this situation to where they might not be able to see you. You understand?
Yes, sir.
I mean, there is an element of personal responsibility, you would agree, right?
Yes, sir.
I mean, once you become an adult, we're all kind of accountable for our decisions that we make and the consequences. Wouldn't you agree?
Yes, sir.
Your attorney, Mr. Burbank, characterized your actions that day as, quote, and I wrote it down, kind of stupid. I think I would beg to differ with that. Shooting a vehicle no less than 6 times as it's moving down the highway. Let me ask you this. Did you know if there was a baby, a child, a kid in the backseat of that Suburban when you fired off 6 shots at it? Did you know if there were?
No, sir.
Could have been, could have.
Yes, sir.
You could have killed a kid as well, in addition to shooting Hunter Freeman, right? This is not how this works. Your attorney can ask you follow-up questions if he chooses to. But
Yes,
you could have killed a kid that day, in addition to shooting Hunter Freeman, right?
yes, sir.
Those bullets could have ricocheted off or went through that Suburban and hit oncoming traffic. Wouldn't you agree?
Yes, sir.
Hunter Freeman could have become incapacitated, lost consciousness, and veered into oncoming traffic or hit another vehicle. Wouldn't you agree? Yes or no? Wouldn't you agree?
Yes, sir.
Okay. Again, Mr. Burbank can ask you all the follow-up questions he wants to ask you.
No, I'm going to object to the sidebar remark.
Overruled, go ahead.
You asked for a second chance, your words. But you would agree with me that you've already had a second chance. In fact, you've had a third chance when you received that first probation and the second probation. Wouldn't you agree? Yes or no? You've had at least 2 prior chances before coming in here asking this jury for probation. Yes or no?
Yes, but not a violent.
Excuse me, non-responsive judge. You are not asked the instrument.
Just answer the question.
Can I say
This,
one thing?
no, this is how it works. Mr. Burbank can get up in just a minute and follow up on any of these questions with any explanations, okay? It'll just be easier if you answer it how it is. Mr. Burbank can stand back up and ask you questions, okay?
You understand those are the rules of court, right?
What's the rules?
What's
Just ask questions.
That's my question.
Yes.
You understand my
Now,
question?
ask a question that has to do with
Well,
this.
I'm gonna tie it in. Just give me one more
Okay.
question. I'll tie it in.
Go
You
ahead.
understand those are the rules of this
Yes,
court,
sir.
right? And you understand that there were rules in the jail that you had to follow too, is right?
Yes, sir.
Did you follow the rules in jail?
I did.
By throwing urine on another inmate that you didn't
It
break
was,
the rules?
it wasn't urine.
Yes or no? By throwing it, well, let me ask, okay, even if it wasn't, by throwing another substance on another inmate.
I got
was that-
gas first.
Listen. Mr. Jones,
I'm not justifying my answer. I'm just saying he asked me a
Listen.
question that comes with explanation. Like it's a
you're,
yes or no.
listen. Listen to the rules. Again, right now in court, listen to the rules. The rules are answer his question. If there's an explanation, your attorney can stand up, ask you for an explanation, and you can give that explanation. That's the third time I've told you,
Yes.
yesterday and now today twice.
Thank you. You didn't follow the rules regardless of what you threw on that other inmate, did you?
I follow the rules in jail.
And that's what you want this jury to believe.
I do.
Okay. You also said that you've learned and reflected on your mistakes. Is that what you want this jury to believe?
Yes, I do.
And this jury will make the determination as to whether or not you can follow the rules. Because probation, you would agree with me, has rules, right?
Yes, sir.
And you violated the rules of your most recent probation by committing aggravated assault, correct?
Yes, sir.
That's the witness, Your Honor.
Thank you, Mr. Burbank.
Asa, when you were trying to explain in reference to the jail, did you have a conflict or beef or having problems with another?
Yes, sir.
And there are rules in jail, right, between inmates,
Yes, sir.
kind of like survival, right?
Yes, sir.
And prior to you throwing whatever you threw, did that person do the same thing to you?
Yes, sir.
And it just kind of boiled over, right?
Yes, sir.
But nothing really, you were sent back to the door.
Yes, sir.
Are you still asking? I know you want to say something. What do you think you want to say that's important to them?
Judge, I would object to the form of that question. That's just an open question about what you want to say.
Sustained, that's good.
Does it have to do with the jail?
The question that I'm, which that
I can't read your mind. I'm gonna tell you that right now. I pass the witness, Judge.
I have nothing further than this defendant, Judge.
Thank you, Mr. Jones. You can have a seat, please. Mr. Burbank?
We rest.
All right, any rebuttal?
No, Judge.
All right, Mr. Coleman, the state has the right to open and close closing arguments.
State waives this right to open, but reserves this right to close, Your Honor.
Thank you, sir. Mr. Burbank, you may proceed.
Please score, counsel, as always. Sometimes as a defense attorney, it's kind of hard when you stand up in front of a jury after the guilt innocence and you return a verdict of guilty. Because you kind of put up your defense and what you think is relevant to the case. And sometimes people think, well, if they're guilty, they just don't believe you. I have a little bit of a different outlook in that, as I said, in Monday, we could not come up to a decision. I told you I believed in the system, and I do. I may not agree with your decision, but I respect it because I respect the system. And this is what we asked you to do. Now, though, we have to decide what is proper punishment. And I know there is not a person on this jury that has a blind eye or is oblivious to what's going on in society today. We hear it every day. I'm busy, sad to say, for representation of what's going on. And when you put together the violence and things that are happening, it makes people mad. And it should. But as I sat here this week, as I sat here at night, because when I get into trial, my focus is you, ladies and gentlemen, because that's the presentation of my case and my client that I've known. And I look at things. And I look at things over the 36 years that I've been practicing in reference to different cases. And I want to submit some things for your consideration, and it's not evidence. I don't condone crime. I represent people that have been accused of crime. And I represent that I very seriously take it that I represent my client to make sure the state proves their case and presents the best I can to the jury. In this case, there's some differences here. I think the end result, very lucky for both sides, that went out in a murder trial and another person has been killed. But there's differences. And the difference is that this crime, as you looked at the jury instruction yesterday, did not have the definition of intentional. It had knowingly and recklessly. And I would submit to you it was probably recklessly. And that's a difference in the legal world. And you're probably wondering where I'm going with this. Asa was on probation. There, you know that. It's a given, misdemeanor. Never been convicted of a felony. Okay, so he is eligible for probation. Asa was going to a friend's house to go fishing. There's nothing to convert that. Anything that says he wasn't doing. Controversial, excuse me. When you look at crimes and offenses that have happened in this society, this is not a crime in where he says, I got mad at you, I don't like you anymore, I'm going to kill you. So he goes to the house or he goes somewhere and shoots and kills somebody. This isn't a crime that says that I'm going to sexually assault somebody and I groom you and and it comes over a period of time and it happens. Or it's an aggravated robbery in which you intentionally want to go into a store to rob, you have a gun, and as a result of your actions, you pull the trigger and you kill the clerk. That's intentional. But there's no evidence that was presented that at June 12th, okay, in 2025, that as he set out, and you know that he was downtown at one time, about 3:30, 3:45 in the afternoon, that he intended to be in a road rage on East Texas Freeway. Wasn't. Now, you heard his testimony yesterday, and that he felt threatened. Okay, now I understand you didn't think that it rose to the standard. I understand. But in his mind, he felt threatened. If he didn't, he probably would never have pulled a gun and did what he did, which is foolish. I'm telling you, don't solve problems. But in that moment, he thought that was the solution, right or wrong. He didn't go out to do this. He didn't go out to say, I'm going to rob you or I'm going to murder you. It could have ended that way, but not. And I think that's where the difference is. The other difference is, and I'm glad that Mr. Hunter Freeman is not dead from where it was. But it bothers me, and it's just me, that somebody would say, I caused this. I taunted him. I said, come on, do it. Basically, if you're going to do it, once he showed the gun, if you take it that he brandished it or he waved it at him, come on, shoot me. And I wasn't going to back down because that's how I was raised. That bothers me. And I ask you to consider that in the deliberation. And that both of them should have parted ways and gone their own ways. Both of them, especially, and Mr. Freeman's included, that if you take it that he's doing 70 miles an hour at 4 o'clock in the afternoon on the East Texas Freeway, and we saw how busy it was, doing what they were doing, would have had some type of sense saying, I'm not going to taunt him. I got to get away from this. Just as Miss Jennings said, what are they doing? They're going to kill somebody. But emotions, the time, the instance, neither one of them were thinking rationally. And I don't say this lightly. I don't. Because this isn't the way society is supposed to be. But I ask you to take that into consideration because I believe, and it's just my opinion and it's not evidence, it's just my opinion for your consideration, that it is a little bit different than other offenses and crimes that we usually see. People going to apartments, going after somebody, going by drive-by shootings because there's an intention of getting in a car and going and shooting up somebody or someplace. Going up to somebody and shooting them because you don't like them at a fight or something like that, you know. But I submit to you that in this case, it was the heat of the moment and it should never have happened. Asa is eligible for probation. I know he was on misdemeanor probation, but it's a little bit different if you're on felony probation. It's a little bit different environment on felony probation if you screw up. You know that there is rules and regulations in reference to what he's going to have to abide by And I ask for your consideration in that. One of the things though is it would have to be, or it can be up to a 10-year period if you assess a 10-year prison term. So that's supervision for up to 10 years on this. If not, as the court has said, there is no jury, there's a hearing. And she determines, she being the judge, determines the violation and whether or not you punish. I ask you to consider that. If it is not probation, I ask you to consider it when you decide the term of years. I don't believe it's worth 40 years. But that's up to your decision. One of the things I do want to point out to you is this. As on page 4, and that is, he's never been convicted of a felony and no more than 10 years assessed. The court will assess the time. I will tell you that it will be 10 years on probation. One of the things is here is the fine. The fine does not go to the complainant or the victim. So when you look at that, it goes to about 32 organizations. One time when we were waiting for a jury, a court, a judge and I, and some other prosecutor. It was like 32 state organizations that get a little bit of whatever the fine is. So I want to let you know that, because a lot of times jurors will say, does it go to a victim or something, restitution, and it does not. I will submit to you, though, that if you consider probation and with a little more hammer, you can assess a fine of $10,000. I would recommend and hope, if you did consider that, that you wouldn't make it payable at this time, but that you would put it over his head, saying, okay, you can still be assessed it if you screw up. I know that you deliberated in there. I know that you looked at everything, except that I wasn't spying on you, but that you took your time and you did what I asked you to do and what Ace asked you. I asked you to do the same thing and take everything into consideration. There's no doubt that society today, the youth, we have a problem. But in the same token, I'm going to submit to you that this offense, this case is kind of unique and different. And that somebody didn't set out to do this. Somebody didn't say this morning, this is what I'm going to do. It is a terrible mistake. He has to pay for what he did. Thank God no one was killed. And I ask you to take consideration of that. And thank you for your time.
Mr. Burbank. Mr. Coleman.
Thank you, Your Honor. May it please the court. Mr. Burbank, ladies and gentlemen of the jury. I want to begin like I began during the guilty innocence phase, where I gave my closing remarks by thanking you all for your time, thanking you for your attention. And I want to say that when I first heard about this offense, I heard about it on the news. I vividly remember it back in June, on June 12th of 2025, watching it on the news, and it offended me deeply. It very deeply offended me that someone, over something so stupid and trivial as being cut off, would shoot somebody in the face. And when this case landed on my desk and I started to review the case and the reports, I remained offended that not only that this was a criminal offense, it offended the penal code, but it offended my sense of human decency. It offended my sensibilities as a member of this community, because it shouldn't be this way. It should not be this way. Mr. Burbank would draw a distinction and everything. This is not the typical gun violence crime that we're seeing in Jefferson County. I submit to you that it is. This is typical of someone who just has a dispute with somebody and instantly goes to the gun, resorts to the gun to settle that dispute. It doesn't have to be this way. It shouldn't be this way. And you can send a message via your verdict to say, we will not tolerate that anymore. This defendant has asked for a second chance. But you've heard testimony and evidence about the fact that he's had at least 2 previous probations. He violated his probation, the current probation, by committing this offense. You saw in that video, he was leaving the probation department. He just met with his probation officer before pulling out a gun and shooting somebody in the face. We had this back and forth discussion during jury selection about rehabilitation. Rehabilitation is great, but remember, it's one of those 3 goals of the criminal justice system. One of which is to punish, the other one is to deter. Punishment, deterrent, and rehabilitation. Rehabilitation only works if somebody's receptive to it. If somebody wants to be rehabilitated. 3 previous unlawful carrying of a weapon cases wasn't enough to rehabilitate this defendant. Okay? It would be nice if we can figure out what his malfunction is, what his defect is that makes him recidivate, that makes him revert back to crime. But that's not our job. Not my job. I'm a prosecutor. Not your job. Your job is to see that justice is done and render the proper verdict in this case. It would be nice to know that, but whatever it is, it's in his nature, ladies and gentlemen. And insanity is defined as doing the same thing over and over and expecting a different result. And if you put this defendant on paper, as they call it, and with the promises and conditions to, I guess, I promise not to shoot somebody in the face again. That's all it is. It's a promise. He made the same promise when he was on probation before. The same promise not to commit a crime. Ladies and gentlemen, that's offensive as well. It offends me that he would come in here after committing this offense and look you in the eye and ask for probation. There are cases that lend themselves to probation. There are situations in defendants and circumstances that lend themselves to probation. A DWI, first time DWI, somebody who evades from the police, they didn't want to pull over because they were scared. Something like that, some property crime or something like that. There are those cases that lend themselves to probation, but it is offensive to ask for it in this case under these circumstances. And I just can't believe that he would even come in here with a straight face and ask you to do that. Ladies and gentlemen, you've got a duty to protect this community. You may not think that what you do in the way of your verdict makes that big of a difference to protect our society, but think about this. Had he been in jail for that previous offense that he was on probation for, then Hunter Freeman may not have been shot in the face. If you let him walk out of this courtroom, who knows what, if anything, he will do. He just doesn't get the message, okay? You also have a duty to Hunter Freeman, a duty to render a just verdict. And when I say justice, I'm talking about equity, something that is fair and on par with the harm that he has suffered. Letting this defendant just walk out of this courtroom, having just been minorly inconvenienced, is not fair or equitable when compared to the harm that Hunter Freeman has suffered. You heard of the long-term effects, having to recall that event over and over, the loss of hearing, the loss of his teeth. That pales in comparison to probation. This defendant, let me say this, 3 weeks from now, you and I, we're going to go on about our business. 3 months from now, you will struggle to remember the names of the participants in this trial. My name, Mr. Burbank's name. 3 years from now, this will be a distant memory for you, for all of you. But 3 years from now, Hunter Freeman will still be dealing with the consequences. He'll still be reliving this. He will still have the physical impairments from this offense. 3 years, 30 years from now. So I submit to you that putting him on probation is not on par. It's not equitable. It's not justice. So please, I implore you, don't do it. Do not put this defendant on probation. And when I talk about the community, I'm not talking about some amorphous term, some term that doesn't really apply to actual people. You saw that video of Miss Jennings' 11-year-old son. He's a victim too, by the way. He saw all of this blood and the aftermath of this individual being shot. You saw how he looked, the look of fear and shock on that child's face. He's a victim as well. Anyone else who would have been on East Texas Freeway that day, they were potential victims. Anybody that would have been in the backseat of the Suburban, they were potential victims. Just a few things for you to consider. I submit to you in your deliberations is you can consider all of the evidence, totality of evidence. You can consider those previous convictions. You can consider how evasive he was. You know, I'm being generous about saying evasive. You can infer that he was just straight up lying to you when he said in all 4 instances, he can't remember where he got those guns from or who he got them from. And in this case, that gun is still out there somewhere, waiting to rear its ugly head, and who knows, God knows whose crime, because it's going to get passed around again on the streets. So you can consider that. You can consider that in your deliberations and in your assessment of the punishment. I brought the evidence of that urine incident in the jail. You know, it's kind of, I will concede it's kind of trivial, but I brought you that evidence because even in a confined, controlled situation there with guards and everything, this man can't follow the rules there. He can't follow the rules on his stand, can't follow the rules of the court. What makes you think, you saw his demeanor up there, what makes you think he's gonna follow the rules of probation immediately? Okay? Don't be fooled. He wants to come in here, cry the crocodile tears, say the right words that I am convinced he practiced before he got here, and try to snow you into giving him a probation. And lastly, his demeanor. His demeanor, I think, is indicative as well. While he may have said the right things, you saw how he was toward the end of my question. I suspect that had I pressed him a little bit more, a couple more questions, the real Asa Jones was about to come out. You saw it. He was ready to go. And had I thought I had a little bit more leeway, I would have gone there with him too. But you saw it, you can assess that. And what I'm saying is, not to be mean-spirited, those are all things that you should and could consider in determining the appropriate punishment for this defendant. I'm just gonna briefly refer to my little chart here because I think it's helpful to see. We can talk about the punishment range, but I think it's helpful to actually see the punishment range. Probation, all the way up to life in prison. I submit to you, this is not a life in prison case. So let's just take that off the table. There are, believe it or not, more egregious cases out there that merit a life sentence. However, on the other end of that spectrum, for all the reasons I just said, this ain't no probation case either. So let's take probation off the table. Now you're left with 5 to 99. Even before Hunter Freeman took the stand, and he and I didn't confer about this and talk about this, in my mind, I already had an idea of what this case was worth, so to speak. And I was thinking that you take the top end of this punishment range off the table. Certainly, you based on everything I just said, you know where I stand on the bottom end of the punishment range. I think you take that bottom end of the punishment range off the table, given his priors, given the body armor. I almost forgot about the body armor. You can consider that. That's in evidence. Who drives around with body armor if you're not law enforcement? Take all that stuff into consideration. His priors, the body armor, the previous guns that he suddenly can't recall where he got from. I submit to you, and most importantly, the nature of the offense. And I'm not going to rehash the nature of the offense. People could have been killed, other people could have been killed, Hunter Freeman could have been killed. That's why I submit, you shouldn't consider the low end. That's why I think you get somewhere right here. And again, I never even talked to Hunter about what I thought the case was worth. But I think remarkably, Hunter and I are on the same page. I will concede, I was thinking probably around 35 is where I was thinking. He was at 40, but I think we're in the same ballpark. And I say that because again, equity, parity, on par with what the suffering that Hunter had to go through for the next 30 or 40 years. Couple things. Whatever sentence you assess this defendant, the jury charge says that you can consider the fact that parole exists. There's some very specific language in there. I would invite you to look at that language about parole because it also goes on to say, well, think back. There is a possibility that no matter what sentence you assess, that this defendant would be eligible for parole with having after doing half of his time. Okay, there's that possibility that he can be eligible for parole. However, that jury charge tells you that's not guaranteed, and that's not something you can say specifically will happen to this defendant. Okay, but you certainly can consider it in the existence of parole and the possibility of parole after doing half of his time. You can consider that in assessing your punishment on this punishment scale, in this punishment range. And another thing, Mr. Burbank and I do agree on the fine. I would suggest to you don't spend any time on the fine. A lot of jurors get back there and they get hung up and start negotiating about the fine. That fine's not gonna go to Hunter Freeman. Who knows what the state will do with it? I would submit to you that you don't spend, even if it gets paid, typically it doesn't get paid. Even if it gets paid, it's gonna go to the state, and who knows what the state will do to it. Sentence him within this range, somewhere between 25 and 50 years. Not because I say so, but because that is justice, ladies and gentlemen. That is both punishment, it's deterrence, and believe me, it's deterrence. The jail will hear about this. The other inmates will hear about this before this defendant gets back to the jail. That's how it works. And also the general public will hear about it. And any other defendant who would even think of doing something so stupid and just reckless, hopefully will reconsider that punishment, deterrence, and while he's in prison, if he chooses to, he can take advantage of being rehabilitated. But that's what I'm asking you to do. I have faith in you. I trust you'll make the right decision because you did the right thing during during guilty innocence. And I'm asking you to do just that this time around. Thank you.
Thank you, Mr. Goldman. All right, ladies and gentlemen, that's all the evidence in the court's charge and closing argument. I'm giving the charge to the bailiff. She'll get you situated in the jury deliberation room where you will deliberate, and we'll be in recess until you reach a verdict on punishment. You guys can go back with the bailiff. All right, let the record reflect state's attorneys present, defendant and defense counsel are present. I've received a message that the jury's reached a verdict. If you can bring the jury in. All right, let the record reflect the jury seated, state's attorneys present, defendant, and defense counsel are present. I would ask the foreperson, has the jury reached a verdict?
Yes.
And is it the unanimous decision of all of the members of the jury?
Yes, ma'am.
Thank you. You can hand it to the bailiff. We, the jury, having found the defendant, Asa Joseph Jones, guilty of the offense of aggravated assault, assesses punishment at imprisonment in the Texas Department of Criminal Justice for a term of 7 years and no fine. You can have a seat. Does either party wish to have the jury polled?
No, Judge.
No, Your Honor.
All right, then, any reason not to pronounce judgment at this time?
No.
Stand.
Then at this time, Mr. Jones, in accordance with the jury's verdict, again, I've already found you guilty, and at this point, you're now sentenced in accordance with that verdict to a term of 7 years in the institutional division of the Texas Department of Corrections. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You've been handed a couple of documents. One is a certification of your right to appeal. You do have a right to appeal, and you can talk to Mr. Burbank about that. You've also been handed a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. If you have any questions about the laws that make you ineligible to possess a firearm or about how long that lasts, you can also talk with Mr. Burbank. Mr. Burbank?
Mr. Lawson, finding.
There, because he was found guilty of the indictment as charged, there is that affirmative finding of the presumption of the deadly weapon. So that will go into the judgment as well. You will be remanded to the Jefferson County Sheriff's Department until your transportation to the Texas Department of Criminal Justice. You can now go back with the bailiff. Ladies and gentlemen, I'll come visit with you in just a minute.
Now, I would point out to all of those angry out there, and I know there's quite a few people who are angry out there. Here, let me show everybody. This guy was already on misdemeanor probation, so whatever time he was looking at for misdemeanor probation is going to be stacked on consecutively, not concurrently with whatever this charge is, because this charge happens separately from the other. I mean, he could technically still be looking at 10 years, but the jury gave him 7. And, you know, that's a lesson. That's a lesson, you know. It seems like a win to a degree, but it's really, well, it's a win for the prosecution, right? They got a conviction. But it's not anywhere close to what anybody was expecting as far as punishment is concerned. But this guy is a 2-time loser, 3rd time's a charm, and he's gone for good. Dude, if you get out of jail and you pick up as much as a pack of bubble gum and you don't pay for it properly and use it very, very respectful language and while doing so, you will find yourself in prison for life. And that's how Texas works. Ladies and gentlemen, thank you very much for hanging out with me. This has been a 3-part epic, really. But next week, tune in for Judge Stevens on Saturday next weekend. We're doing the same thing we did this weekend. Judge Stevens' case is a jury trial also, but it's only in 2 parts, not 3. So we'll start Saturday morning and we'll end it Saturday night. We'll see how it all turns out. That one I'm billing, do not bring a gun to a fist fight. And I want to say thank you to all of my friends who came by and hung out with me tonight. You start these credits running while I say thank you to Darth Steven, CE, Northwest, Miss Natasha Kitty. Thank you so very much for hanging out with us tonight. The super chats and the special thingamabobs were also awesome. Chat has been amazing and fun, as always. And interesting. I think we all learn a little something here. These situations are out of this world. Mama Wolfie's right. We appreciate our viewers so very much. I don't know what that means, Northwest. No NG, no sentencing. I don't know what that means. Oh yeah. No, there could be a sentencing in that one, Northwest. I will just point out that maybe it's just a little bit shorter than this one with Judge West. That's all it is. That's all it says. I was able to compress it a lot more and get it all in just 2 sittings as opposed to 3. That's all that is, more than anything else. It is the John Dixon trial. If you're interested, Northwest, and you want to look it up ahead of time. But for now, I am your Northwest. I am your Lone Wolf Uso. I am your nutty host who puts all these little compilations together in this epic 3-part series with this road rage craziness. For now, until tomorrow, same wolf time, same wolf channel. I am out. Thank you all so very much for being here. And remember, only you can take a bite out of crime. Bye! Meow. Boo. bet you didn't expect to see me again, did you? Well, I didn't expect to see you either. Why are you here? We're done. This is not Ferris Bueller's Day Off. I'm not doing secret end screens every single night after I turn the stream off. It's not going to happen. I got nothing else. Go away. Bye.